Hello, good morning, everyone. Um, I'm going to this video. I think I'm going to combine Family Hive and Betty Buzz and do the corporate entities. Get them out of the way. It's still quite spicy, actually. I haven't gone in them in detail just yet, but I've kind of skimmed, and there are interesting bits of information. Before I do that, though, I just want to say, by the time I was kind of up and out the house at 5 o'clock in the morning yesterday, and we spent the whole day at the hospital. So, two things. I did get a couple of videos done, but I have not had time to respond to everyone's comments. I always respond to comments, so I'm just a bit behind. If you've left a comment, and I know someone's a couple of people actually have left a couple of super chats as well. Thank you so much for that. I will respond. I'm not ignoring anyone. I was just exhausted last night. I also want to just thank everyone. It didn't occur to me actually because I have mentioned that my little hospital, but I just didn't think to say everything went fine. So everything did go fine. It went as well as it could be expected. She's got quite a long, difficult, it's going to be a bit of a bumpy recovery. So we'll get her through that. She's she's incredibly strong. She's inspirational. She's been through a lot for her very young age. She's been through, a huge amount and still continues to go through a lot as well. But, everything went as well. The care from the hospital was incredible. So yeah, a lot to be thankful for. And I'm just really appreciative, actually, that so many people took time to just send a little message or, or to include it in, their comment about the video itself, sending hugs and loves and well wishes. So thank you so much for that. Every single comment means a lot. So I wanted to update everyone on that. I'm sorry, didn't occur to me to do that last night. But there we go. So yeah, everything went well. So Blake Lively, let's get back to that. So I haven't got much to say about this one actually. So this is just really quickly. Blake Lively has filed a letter, basically saying, Judge, how silly of me. I forgot to add these additional things I want sealed in my letter last week. Can I do this now? Can I just add this quickly now? So that's what this letter is. There's a couple of exhibits that she's saying that she forgot to include, and here's an amended, here's a notice to correct my letter motion. Let's have a look. So, dear Judge Lyman, Plaintiff Blake Lively respectfully submits this notice to correct Ms. Lively's letter motion for limited continued sealing, filed January 5th, and to provide the court with a corrected copy of Exhibit B to Ms. Lively's letter motion. Exhibit B is under seal, so I can't look at that. Ms. Lively seeks partial continued sealing of 39, 108, and 206, all of which implicate third parties' privacy interests, and which were inadvertently omitted from Miss Lively's letter motion and Exhibit B. A corrected, sealed copy of Exhibit B is enclosed herewith. Can she file this? Yes. It's pretty much up to the judge. Wayfarer, I would be surprised if they did not file something back and say, well, hold on a minute now, that was untimely. Or, you're just trying to circumvent the process to add a few more things in. It's going to come down to the judge, basically. So I can't really predict what's going to happen there. I'm skeptical. It may be that it was a genuine error. And if you're out of time, you're out of time. Unless there is really good reason. Her reasons are that it implicates third parties' privacy interests. But I mean, that's so generic. Like, who are the third parties? What privacy interests are we talking about here? Are they relevant to the claim or not? Because if they're relevant to the claim, then just saying, well, they're entitled to their privacy is not enough. So if it's medical information, well, then that's going to clearly be enough. So it's really hard to sort of weigh in an opinion on this, on what Lyman's likely to do, because there's just not enough information. But I just love the fact that she's, to me, it feels like she's pulling a fast one. But, that's the skeptical person I have become following this case and dealing firsthand with Blake Lively's attorneys. Okay, so where are we going to go first? I think Family Hive. So Friedman took these ones, actually, both Family Hive and Betty Buzz. I got quite excited yesterday because Friedman also did Sony response as well, which was just brilliant. Love a Friedman filing. We haven't seen too much of them, like, since he got kind of struck down with the Taylor Swift thing. I think he became aware that, if he filed something, Judge Lyman was more likely to say no, or to kind of, say or do something to berate him a little bit, shall we say. But I mean, he's also been very busy with other cases too. But I am enjoying seeing a little flurry here of some filings from him, especially given that he was recently admonished as well. So yeah, this is always good. This feels good. Okay, so this is Family Hive. Dear Judge Lyman, on behalf of Wayfarer parties, we write in response to non-party Family Hive motion to seal. As explained in the motion for summary judgment, the Wayfarer parties take the position that none of Family Hive's information has any relevance to Miss Lively's claims, because as a matter of law, she lacks standing to seek damages for the company's lost profits or Lol Hatter LLC's lost royalties. An LLC and its owner or members are not interchangeable for the purposes of standing, and an individual lacks standing to sue when the alleged injury is based on an injury to a corporate entity. But although the Wayfarer parties contend that none of the evidence Family Hive seeks to seal should be admissible at trial, future determinations of admissibility do not govern the sealing inquiry. The court has been asked to rely on the materials Family Hive now seeks to seal in determining the Wayfarer party's summary judgment motion. For purposes of evaluating the motion for summary judgment, the court should not seal any documents that Miss Lively produced and placed squarely at issue as the basis for her damages, especially when Family Hive cannot identify any competitive harm that might result from disclosure. The Supreme Court and Second Circuit have long held that there is a presumption of immediate public access to judicial documents under both the common law and the First Amendment. The presumption of public access is at its highest when the material is relevant to a court's decision on a dispositive motion, such as a motion for summary judgment. Where the presumption applies, continued sealing of the documents may be justified only with specific on-the-record findings that sealing is necessary to preserve higher values, and only if the sealing order is narrowly tailored to achieve that aim. This court has observed that sealing of business information may be appropriate as to certain confidential business information that has no bearing on any issue in this case, and that would cause substantial harm to a party or non-party's competitive business. In determining whether such information is properly sealed, courts may look to whether the information is still relevant to the business and the degree to which a party would be competitively harmed if the information were revealed. There is no basis, however, to seal stale information that no longer poses any competitive threat. The older the information is, the less appropriate it is to seal that information. Family Hive has failed to overcome the presumption of public access because it failed to show that the information it seeks to seal, 1, has no bearing on any issue in this case, 2, is still relevant to its business operations, or 3, would competitively harm it if the information is revealed. Family Hive seeks to seal the following documents. So, 1. Deposition pages. Wayfarer Motion Exhibit 273 and Lively's Opposition Exhibit 87. Family Hive seeks to seal portions of pages from the deposition of its Rule 30b6 witness. Page 137, which it seeks to seal, concerns discussion of Family Hive's retail weekly sales from October 2024. The information is directly relevant to Ms. Lively's claim that Family Hive's sales declined due to negative publicity. Moreover, the stale information is from more than a year ago, and Family Hive has not shown that it would be competitively harmed if it was released. The information contained in Exhibit 87 relates to Lively's claim that sales declined significantly due to defendants' alleged retaliation. Ms. Lively has placed the information directly at issue regarding her claim for damages related to Family Hive in excess of redacted. The motion for summary judgment argues that such damages are overly speculative. Thus, the court must evaluate this evidence as part of its judicial function. Finally, the identity of the corporate non-parties who Family Hive wish to conduct business with does not implicate privacy concerns. 2. Lively expert Jeff Kinrick report. Family Hive seeks to seal portions of the expert report submitted by Ms. Lively's expert Jeff Kinrick. The fact that Ms. Lively's expert relies on Family Hive's information establishes the information's relevance to the motion for summary judgment. Family Hive points to the following specific portions of the reports it seeks to seal. Page 2. This proposed redaction simply identifies an assumption Mr. Kinrick makes and does not implicate Family Hive's business information. Pages 6 and 24 through 26. Backup Exhibit 1B, 3B, Appendix C1 and C2 all relate to Family Hive's sale performance, which is the basis for Ms. Lively's damages claim. Moreover, Family Hive has not established how this information would cause competitive harm. The Wayfarer defendants do not oppose the sealing of the name of the individual in footnote 95 to the Kinrick report. Page 11 relates to Mr. Kinrick's prediction, not Family Hive's predictions. Moreover, Family Hive has already testified that redacted, so the disclosure of redacted could not competitively harm it. Pages 16 through 23, Backup Exhibit 1A, 3A, and Appendix C3 relate to stale cash flow forecasts created by Deloitte in July 2023, a year before a single product was ever even sold. Moreover, redacted. Page 35 relates to royalties paid to Lol Hatter, directly relevant to the fact that Miss Lively does not receive royalties and has no stand-in to bring a claim for damages based on lost royalties. So she's claiming royalties but does not receive them. I mean, some might describe that as fraud. Backup Exhibit 1C, Appendix C4 and C5 relate to Mr. Kenrick's projections, not Family Hive's actual data. And then 3, Lively expert Dina Maislin report. Family Hive seeks to seal portions of the expert report submitted by Miss Lively's expert Dina Maislin. The proposed redactions all relate to Family Hive's sales performance, which is the basis of Miss Lively's damages claim and the subject of the argument that Miss Lively's claimed damages are too speculative. As Family Hive has not met its burden to overcome the right to public access of information used in evaluating dispositive motions, the court should decline to seal any information requested in Family Hive's motion. All right. And then we have Betty Buzz. This may probably go along a similar thread, but we'll see. All right. Dear Judge Lyman, the Wayfarer parties write in response to Betty B. Holding's motion for sealing. As explained in their motion for summary judgment, the Wayfarer parties take the position that none of Betty B.'s information has any relevance to Miss Lively's claims because, as a matter of law, she lacks standing to seek damages for the company's lost profits. Therefore, none of the evidence Betty B. seeks to seal should be admissible at trial. However, future determinations of admissibility do not govern the sealing inquiry. For purposes of evaluating the motion for summary judgment, the court should not seal any documents that Miss Lively placed squarely at issue as the basis for her damages. Okay, so it started exactly the same, and this next paragraph will be exactly the same. But we'll go with it. The Supreme Court and Second Circuit have long held that there is a presumption of immediate public access to judicial documents under both the common law and the First Amendment. The presumption of public access is at its highest when the material is relevant to a court's decision on a dispositive motion, such as a motion for summary judgment. Where the presumption applies, continued sealing of the documents may be justified only with specific on-the-record findings that sealing is necessary to preserve higher values, and only if the sealing order is narrowly tailored to achieve that aim. Between the motions last week and the motions that come in last night, I have repeated that quote over and over and over again. It's a quote from some case law. The reason it is being cited is because all the parties need to establish the standard. They need to kind of, make it clear what they're relying on. Okay. This court has observed that sealing of business information may be appropriate as to certain confidential business information that has no bearing on any issue in this case, and that would cause substantial harm to a party or non-party's competitive business. In determining whether such information is properly sealed, courts may look to whether the information is still relevant to the business and the degree to which a party would be competitively harmed if the information were revealed. There is no basis, however, to seal stale information that no longer poses any competitive threat. The older the information is, the less appropriate it is to seal that information. Betty B. has failed to overcome the presumption of public access because it failed to show that the information it seeks to seal, 1, has no bearing on any issue in this case, 2, is still relevant to its business operations, or 3, would competitively harm it if revealed. Betty B. seeks to seal the following documents. Okay, so now we're past the generic part, and this is the more tailored part, which will be specific to Betty B.'s, as a response to Betty B.'s motion. Okay. 1. Betty B. operating agreement. Betty B. seeks to seal its second amended operating agreement, arguing it has extremely limited relevance to this action. Not so. Ms. Lively claims up to redacted. However, the operating agreement establishes two key facts that are dispositive of Miss Lively's claims with respect to alleged Betty B damages. 1. Redacted. In other words, Miss Lively, a Betty B board member and the party who produced the document, has placed redacted directly at issue. So I'm guessing that 2 was also redacted in amongst that big block there. Betty B also fails to establish that the second amended operating agreement is still relevant to its business, given that as of June 2025, Betty B had entered into a redacted. Okay. As a footnote, the extent of the differences from the second amended operating agreement are not fully clear to the Wayfarer parties, given that neither Miss Lively nor Betty B produced redacted. Nor does Betty B explain how disclosure of the operating agreement could or would harm its business interests, other than to claim that it explains how Betty B decided to structure and manage its business. 2. Board updates. Betty B seeks to seal 2 board updates because they contain sensitive, competitive business information. And then we have a footnote. Betty B does not explain what specific portions of the board updates contain sensitive information. So she's wanting to just seal the whole thing, not the parts which she is claiming has sensitive information. However, Betty B admits the information is a key component of Miss Lively's claim, noting that Miss Lively's experts rely extensively on information from these documents. Moreover, the board updates were produced by Miss Lively with redactions removing information she or Betty B deemed irrelevant to this action. Notably, these board updates were only included in Miss Lively's opposition to defendant's motion for summary judgment as part of her argument that defendants caused Betty Booz's lost sales. The documents are thus directly relevant to the performance of the judicial function. Okay. As the court must, So the documents are thus directly relevant to the performance of the judicial function, as the court must evaluate them to test Miss Lively's assertions. For example, the board updates redacted, supporting the argument that Lively's damages are too speculative. Indeed, Miss Lively's expert, Jeffrey Kinrick, relies on the board updates in opining that redacted. 3. Miss Lively's expert reports. Betty B seeks to seal portions of 2 reports submitted by Miss Lively's experts. As noted above, the fact that Miss Lively's experts rely extensively on Betty B's information establishes the information's relevance to the summary judgment motion. Betty B seeks to seal the following portions of the expert reports. Kinrick. Most of the information contained in this section comes from publicly available sources. The small portions related to Betty B's decline in sales form the basis of Miss Lively's damages claim with respect to Betty B. Kinrick, Section 8 and Exhibit 2. The very title of Section 8, Redacted, emphasizes the basis for Miss Lively's damages claim. Moreover, Section 8A describes Mr. Kinrick's opinion of redacted. However, redacted, Section 8B, describing purported redacted, forms the basis for Miss Lively's claim. Kinrick, Appendix D, Mr. Kinrick's calculations of lost profits form the basis for Miss Lively's damages claim. The motion for summary judgment argues that such calculations are overly speculative. Maislin. These pages describe Betty B's financial performance in the context of Miss Lively's claim for damages. The K1 statements. Betty B seeks to seal 2 K1 statements because they contain financial results for 2 years. The K1 statements only show the share of income for Betty B member Lol Hatter. Redacted. Betty B's financial results are not included. The documents directly relate to the Wayfarer party's lack of standing argument. 5. Deposition pages. Betty B seeks to seal 2 pages from the deposition transcript of its Rule 30b-6 witness Andrew Chrysomalis. Page 121 describes Betty B's expectation of Betty Boo's sales for 2024 as of October 1st, 2024. Betty B does not describe how disclosure of this stale information could competitively harm it. Page 147 describes how redacted. Again, disclosure of this stale information could not harm Betty B. As Betty B has not met its burden to overcome the right to public access of information used in evaluating dispositive motions, the court should decline to seal any information requested in Betty B's motion. So when I did the original motions from these two entities, my sort of opinion at that point was they're strong and they're likely to get it because, competitive information and sort of trade secrets is, one of the umbrellas for the protective order and therefore sealing. But now I've read this and we now have the context that is always missing in these kind of lively sided filings. I'm actually inclined to say that I don't think that they should have their sealing motions granted, for the reason that, as Wayfarer eloquently pointed out, this is old information, it's irrelevant information, it's information that Lively has squarely placed at issue, it's information that her experts have relied upon extensively for their reports, it's information that she put in specifically to oppose, a part of Wayfarer's motion for summary judgment. So I think, these are really, really good filings, really good oppositions. And I don't think that the entities should be granted their sealing requests at this point. I've changed my mind. Okay, I have got so many more filings come down. I have got to go through and work out whose is what, and then I'll do some videos on them. All right, guys. I'll be back later.